Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to look at a case out of the Court of Queen's Bench of Alberta. This is a case that could have potentially big impacts for airsoft and paintball, notwithstanding the fact that no airsoft or paintball guns appear in this case. But it does involve Section 84 Sub 3, which is critical to airsoft and paintball issues. I'm going to go through this and try to explain it. It hinges on some fairly technical legal issues. So the impact of this may not be immediately obvious. I'm going to try to explain what's going on in this and why it matters. So this is the case of the Queen and Dillman, and so we'll just dive in here. So in the trial of this matter, an evidentiary issue arose as to whether the Crown or the defense bears the onus with respect to the words where it is proved in Section 84 Sub 3 of the Criminal Code. The item in question was a sawed-off .22 caliber rifle. So I'm going to explain what all that means, but first let's go through what Section 84 Sub 3 says. So that subsection reads as follows. For the purposes of Sections 91 to 95, 99 to 101, 103 to 107, and 117.03 of the Act and provisions of the Firearms Act, the following weapons are deemed not to be firearms. So any other barreled weapon where it is proved that the weapon is not designed or adapted to discharge a shot, bullet, or other projectile at a muzzle velocity exceeding 152.4 meters per second, or at a muzzle energy exceeding 5.7 joules. So that's the first section. The second part is basically the same numbers, but if it attains that speed. The reason why they have those two separate provisions is because the first is if it's at the muzzle energy, but we're also considering things like gyrojets or rocket launchers, where it may fire out at a lower speed, but then speed up as it goes. Most things don't really come into that category. Most things you're worrying about the muzzle energy. So the key bit here is the where it is proved. The dispute that comes up is basically the Crown is saying that the burden of proof on that should be on the defense, that the defense has to prove that it fits within this category. Whereas the defense is saying, no. Other way around, the Crown has to prove that it doesn't fit within this category. So you can see how that ends up mattering, because if the evidence isn't called or isn't available, that can really change how the case ends up going. So let's have a look here at continue on. So this subsection applies to offenses related to the possession, trafficking, transferring, and importing and exporting of certain firearms, and the failure to report or the false reporting of the loss, finding, or destruction of those firearms. Those firearms being prohibited firearms, restricted firearms, and non-restricted firearms without a license or registration certificate. It deems certain barreled weapons which discharge a bullet at a velocity of less than 152.4 meters per second, or about 500 feet per second, either at the muzzle or at any point thereafter, or of a muzzle energy or flight energy less than 5.7 joules, not to be firearms. So that's dense, language, but it's very accurate language. I really like this summary here. This is a good summary. When we're talking about what kind of guns those are, airsoft guns, paintball guns, those are the, some BB guns and pellet guns. Those are the big categories that are captured here. So they say, therefore, in this case, notwithstanding my conclusion to this point regarding the application of the definition of firearm to this barreled weapon, this section may deem the sawed-off .22 caliber rifle not a firearm. Now you might be saying, well, why are they using the language of weapons here? Airsoft guns and paintball guns aren't weapons. Unfortunately, in Canadian law, they are. It's just the way our law works. Our law does not always make the most sense, and this is an example of it. This subsection thereby provides an exemption. It exempts anyone possessing a low-powered barreled weapon from the requirement of holding a license or other authorization which may be required for a firearm. What this means is that any person can own any barreled weapon that fires a shot, bullet, or other projectile without a license, so long as it does not exceed the velocity and energy set out in the subsection. The point of this exemption is not to sweep in, as a firearm, low-powered barreled weapons such as BB guns, pellet guns, and the like. Airsoft and paintball being big categories here. What Parliament has done has set a standard below which any owner of low-powered barreled weapons can enjoy the use of the barreled weapon without bothering to acquire a firearms license. Again, this is really important because it's very doubtful that the paintball industry would survive otherwise. And airsoft and various other things. So the onus, Crown or defense. The defense and Crown dispute who has the onus to prove the velocity or energy. In respect of defenses, the law is clear. the accused need not prove a defense. As the Supreme Court stated in the Queen and Holmes, all that the accused need do is point to some evidence which supports the defense. So you have to raise the issue somehow, and that can be raised on defense evidence or on Crown evidence. You can simply say there is some evidence that says that this is relevant here or that this is an applicable defense. The Crown is then required to disprove the defense beyond reasonable doubt. The law seems to be more complex in respect of exceptions and exemptions. So let's consider an example of what they mean by, point to some evidence which supports the defense. So self-defense is a very common example of a defense. So let's say somebody breaks into your house and they have an axe, and in the course of some transaction, and there's going to be a dispute as to what happens inside, because, we're talking about a situation where someone's charged, but that person who broke in with the axe is dead. You can point to the fact that they broke into your house and that they had an axe as being enough to raise the issue of whether self-defense is on the table. That's enough, right? It just makes it that it's a live issue. It's a possibility. But let's say instead this happens, at a crowded, event. You're up on stage and you walk up to the person who's on stage and they haven't seen you, but 1,000 other people see you, and you put a gun to the back of their head and you shoot them. And then, if you were saying, hey, self-defense is on the table, it'd be like, what evidence of self-defense is there? So that's a situation where there wouldn't be sort of an air of reality to the self-defense argument, and a jury wouldn't have to hear about self-defense. So ordinarily in a trial, the Crown need not disprove an exemption. So there's a big distinction here between exemptions in the law and defenses in the law. Now, this is something that has never made a whole lot of sense to me, because a defense and an exemption are kind of two flavors of the same thing. It's illegal to kill somebody except in self-defense. Yeah, this is a very technical area. I would love to see the courts just say, hey, listen, all of these things are defenses. It's a defense to say I fall within this exception. But that's not going to happen at this stage. We're going to have to deal with this for a while longer until something gets sorted out. But for right now, this is an important distinction of defense versus exception. So Crown is arguing this is a defense. Defense is arguing that this is a defense. Crown is arguing that this is an exception. All right, continuing on here. It seems that this principle entered the common law, and this principle is that distinction between exceptions and defenses, as well as the onus being on the accused with respect to exceptions. So it seems that this principle entered the common law, and thus neither the limitation contained in former section 794 sub 2 nor its repeal preclude the application of this principle to indictable offenses. In the Queen and Edwards, the English Court of Appeal addressed the question of whether the Crown must prove a lack of exceptions contained in a statute. And big, long old British language, so we'll skip over that for now. In the Queen and Volk, the appellate division held that the burden of proof of establishing the statutory exception to the indictable offense of gross indecency, that the consenting complainant was 21 years old, rested on the defense. A similar result was reached in the Queen and Duchesne, where the court addressed the proof burden escorting the statutory age exception to the indictable offense of buggery, which has since been repealed because, yeah, that was a bad set of law. So basically they were saying that proving that somebody was 21 years old was on the defense. That's got its own sort of wrinkles on it. So I'm aware of only one reported case where the onus in section 84 sub 3, that's this critical bit of law that we're talking about here, was considered. In the Queen and Binns, an oral decision from the Ontario Court of Justice, Judge Bellefontaine stated, and I'm going to skip over lots of this because lots of this is not super applicable. But they say the Crown secondly submits that the section is a qualification or exemption that the Crown need not prove. The wording of the section, where it is proved, arguably places an evidentiary burden on the defense that may reasonably be placed on the defense, as cases may exist where the item is proven by circumstantial evidence to meet the Section 2 definition of a firearm, but has not been seized by the police to be tested for Section 84.3 compliance or 84.2 compliance. That might be an old phrasing of the law, or it might be that they've put points where they mean brackets. In such circumstances, if the accused alone had access to the firearm, the muzzle velocity would be information that the defense alone could obtain. Kind of, except it's very unlikely that people measured their own, firearms, and there's various ways that that could be established. But the problem of missing evidence is kind of a problem that shows up all through the law. We don't normally say, well, because evidence can go missing, the Crown's going to have a reduced burden of proof. It might be a lot easier to prove that the accused stabbed somebody if you can find the knife with fingerprints and blood and all of those good things. But we don't say just because the knife might go missing that the Crown doesn't have to prove that it was the accused that stabbed the person. So this bit about that, missing evidence here seems to me to be a bit of, I don't know that I necessarily agree with this. We'll go with that. So I get where they're saying, maybe they're putting the burden of proof on the defense because of that issue. But, that happens all the time. Continuing along here, they say, absent clear language or statutory or common law authority, it is inconsistent with the presumption of innocence to impose the burden on the defense to prove the point. I regret the bizarre interpretation this creates where opposite results occur depending on the whim of the Crown in making their election. And that doesn't really apply here. However, the result can be justified. In the event the Crown wants the benefit of the increased penalty available when proceeding by indictment, they must be prepared to forego the evidentiary shortcuts available in summary conviction proceedings. What they're talking about is a section of the criminal code that allowed for essentially the exception rule to apply differently in indictable versus summary conviction proceedings. For the foregoing reasons, the Crown bears the burden of proving the firearm's velocity for the applicable sections whereby a firearm is an essential element of the offense. In reaching this anomalous conclusion or bizarre interpretation, Bellefontaine was bound by the narrow approach set out in the Queen and H. In contrast, in Alberta, the law is set out in Thompson and Volk. So there's different laws as to how this works, which is complicated and a disaster and not something we're going to worry about too much in this video. But whenever we see this kind of differing interpretation, that suggests that maybe this case needs to go up to higher courts to get things sorted out. We're not clear on that yet. So given the lack of authority, I turn to first principles. We don't have a whole lot of helpful case law, so we're going to have to go and look at things from the ground up, basically. The law generally imposes an onus on the accused to invoke the exemption provided in Section 84 sub 3 and to provide an air of reality to the claim that the weapon at issue is not, in fact, a firearm. After all, the accused will be in the best position to know about the existence of any authorizations or to show that the weapon is an antique, a starter pistol, or device associated with animals. This conclusion is consistent with Thompson and Volk. I don't know that the accused is necessarily in the best position to know about that. I'll talk about that a little later. However, the specific exemption set out in Section 84 sub 3 sub D gives me pause. Parliament adopted a highly technical definition. This definition frequently comes up in cases involving pellet guns and air guns. The determination of pellet guns' muzzle velocity is commonly referred to as the pig's eye test because the muzzle velocity listed in Section 84 sub 3 sub D is required for projectiles to penetrate the human eye, and pig's eyes are similar in size and composition to human eyes. This, unfortunately, is wrong. The determination in terms of Section 2 is the pig's eye test. The determination in Section 84 sub 3 sub D is substantially higher than the pig's eye test, which for airsoft guns, the CBSA takes the position of at around 366 feet per second. For paintball guns, it's actually substantially lower. For pointed lead BBs, it's lower still. In terms of things puncturing eyeballs, that's what makes them Section 2 firearms. So that's what makes this a live issue in general, but that's not the 84 sub 3 cutoff. So this is actually a misreading of a whole lot of things. It's a misreading of the scientific evidence. It's a misreading of the previous cases. This is a problem because whenever you see an issue like this, it potentially opens things up for did the court make a mistake? And here I think they made a mistake. I don't think it's a mistake that affects the underlying decision, but it is a mistake. And that's unfortunate. So considering the state of most accused, it is unlikely that they would be able to have access to or afford the requisite testing. Placing the burden of measurement of velocity on the accused strikes me as being akin to requiring an accused to provide evidence with respect to the measurement of electricity or the torque of an engine. Requiring the accused to present such evidence would impose an undue and unreasonable burden on the accused, which is fair, right? Because, I mean, when they say considering the state of most accused, they mean that the average accused person is poor, may have mental health issues or cognitive issues or other sort of, they may have other personal issues in terms of their mental state. They may have addiction issues. They may have medical issues. They may have all sorts of other things going on that make them less able than your average bear to take care of basic tasks, let alone more complicated tasks. In terms of the requisite testing, I mean, you can buy a chronometer, and lots of people in the airsoft community are going to be super keen on knowing what velocity their airsoft gun shoots at any given time. But proving that might actually be a little more difficult because, they'll say, well, was this tested in scientific conditions or was this tested by some guy at an airsoft field? That's an important question, right? Is that some guy at an airsoft field enough to establish this? The other thing that occurs to me is that we actually have really interesting provisions in terms of the firearm business licenses. You can possess prohibited firearms for the purpose of testing. You can set up a business for that purpose, for the purpose of providing testing to the police or the Crown, but not for the defense, which creates a very interesting situation of if you want independent testing of the muzzle velocity of an airsoft gun, there really isn't a place to do that because most airsoft guns, they'll say, if they're saying it's a firearm, they're going to say it's a prohibited firearm because most airsoft guns, the way they're designed, they will fall into that category, either because they might be a short-barreled handgun, because there's a lot of handguns out there that are designed after short-barreled handguns, or because they can fire more than one shot with a pull of a trigger. They're fully automatic. So there may be very real questions as to whether you can actually get that airsoft gun tested. And you might say, hey, Crown, I insist that you test this. And the Crown might say, no, we're not going to do that. You get into issues of, can the Crown be compelled to do this testing? Can you require them to generate this evidence? And that's its own question. So the defense may not necessarily be in the best position. They may be in a situation where it's quite difficult for them to obtain this. In the lost gun scenario, where you say, hey, what happens if this is never recovered? Somebody points what appears to be an airsoft gun or what is believed to be an airsoft gun, and then they chuck it off a bridge. And so you never find it again. It's gone. Well, did the accused test it? Can the accused provide, certification of its testing that day? Probably not. But this seems like an evidentiary gap that normally works against the Crown in any event. So I kind of feel that this is the right call in terms of trial fairness. The other flip side to this is consider the legal burden that that the other way puts on airsoft and paintball owners. It basically means that you are potentially, arrestable at any time for having these things, and you would have to provide proof at trial that this was an airsoft gun or a paintball gun and fell within that range. Well, that becomes tough. I mean, are we all going to go around and start documenting the muzzle velocity and the, and the energy of the things we're firing? That's a tough thing. So this would actually put a tremendous burden on the airsoft community if it goes the other way, and the paintball community. So this is a really good decision for protecting those communities from over enthusiastic application of the law, basically. Continuing on. My conclusion in respect of 84 sub 3 is reinforced by the inclusion in the stem of this provision of the words, where it is proved that the weapon is not designed or adapted to discharge. This wording appears to anticipate that this is part of the element of the firearm, and that it is the Crown who has proven the weapon's muzzle velocity or projectile velocity. Finally, I note that Section 84 sub 3 does not contain the usual phrases which denote an onus on the accused, such as absent evidence to the contrary, or the proof of which lies with the accused. So they're saying if they wanted the proof to be on the accused, they could have put that in the law. They didn't put it in the law. I'm not going to do that for them. Conclusion. In sum, I agree with Judge Bellefontaine that, absent clear statutory language, it is inconsistent with the presumption of innocence to impose the burden on the accused to prove muzzle velocity or projectile velocity. I conclude that it is the Crown who bears the burden of proof in respect to Section 84 sub 3 sub d. I'm aware of logistical problems commonly besetting the Crown, causing the Crown to experience significant delays in obtaining certificates from government labs in a timely manner. Nevertheless, that does not relieve the Crown of the burden to prove all elements of a charge. You might be saying, what is this talking about? Well, when the Crown wants to prove that a gun is a gun, they got to go and get it tested. They can't just say, hey, well, it looks like a gun, so it's a gun. That's not usually good enough for the courts. So typically this has to get sent off to a lab and they fire it under lab conditions. They do a bunch of testing and a bunch of, so forth. And in some cases, this is real straightforward. We put cartridges in it. We pulled the trigger. It fired. It made a hole. It fired at this velocity. It's clearly a gun, and it's clearly not an 84 sub 3 gun, or it is, or whatever else, right? But this takes some time. You got to have people doing this. And of course, everything is underfunded. So they send these off and, they say, hey, we've got a trial date in 6 months. And the lab says, that's great. Our backlog is 9 months. And so trial rolls around and they don't have the certificate. And then they lose the case. So the Crown is saying, listen, this is a real big problem for us. We don't have the budget. We don't have the resources to get this done. And the court is saying, well, tough. The answer to that isn't to reduce the burden of proof and to just say, oh, well, if it's expensive, I guess you don't have to prove it. They're saying, no, either fund it or don't. That's your call. But we're not cutting evidentiary holes in this just because you've decided not to fund it. That's not the way the law works. So I agree with this 100%. Now, I will just note as an aside, the government has proposed a buyback that is, estimated at costing something like $2 billion. It would seem to me to make a lot more sense not to ban the things and to instead put $2 billion into solving this lab problem, because this lab problem is actually aimed at criminals. It's actually aimed at people who haven't bothered to get a license. So solving that makes more sense to me, but what do I know? So therefore, notwithstanding that the sawed-off .22 caliber rifle otherwise meets the definition of firearm, having reached the conclusion that the Crown must prove the velocity or energy as part of proving the barreled weapon as a firearm, and not having that evidence that proof of the element in the first 3 charges in the indictment fails. So basically, this is a situation where the Crown has failed to call necessary evidence and thereby failed to prove their case, and, this person is acquitted as a result. Now, you might be saying, I'm not super happy with that because that's a .22 caliber that's a .22 caliber rifle, and, it's a sawed-off .22 caliber rifle. So this is not an airsoft gun. This is not a paintball gun. And I will say that there's not a lot of sawed-off rifles that are kicking around in the general sphere of law-abiding gun owners. I will probably, make the assumption, and I can't say 100%, but I'm going to make the assumption that these are probably individuals who were up to some form of no good. And, again, I can't say for certain. I don't know anywhere near enough of the circumstances here, but it seems probably up to some form of no good. So you might say, well, that's real sad, except you can see how this decision actually protects, the guy who's just going to the paintball field, the guy who just goes to the airsoft field, the guy who runs the store. Can you imagine having to keep records of what the muzzle velocity is of every paintball gun at your paintball store or every airsoft gun at your airsoft store? People want to open a box and get something that's, an unopened box, not something that the store owner has had to take out back and fill with, gas or charge up and shoot. They want something that's new, not something that's been used. So all of this basically relieves the community of what would otherwise be a fairly substantial burden. So I like this case. I think this is a good case, but it's a potentially difficult case for the Crown, so there may or may not be the potential for this to end up getting reviewed by a higher level of court. If it does, of course, I will follow along with that. I also want to give some congratulations here to the council who won the day on this. Amy Lind and Kevin Gubbins both did from what I can tell here, did a fantastic job. This looks like they argued this well and carried the day. I wasn't actually there, so I don't know. It might be that the judge did all the work, but I kind of feel, I know these lawyers, I know they will have done their homework on this. Anyway, as I said, this is a big deal. I kind of wanted to share it with you. Hopefully I've made it clear. If not, please let me know in the comments below, and I'll try to explain and try to provide some clarification if it's not clear what's going on here. Anyway, thank you for watching. Please like this video. Please share it with your friends. Subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: Jason Elliott, Demo, Canada's National Firearms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, BCAMF.org, Andrew Schaefer, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Matt Ward, Mark Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Adam Meester. Sorry about that. As well as a number of you at the $10 level who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge, and see you next time.